Everybody, it's so excited to have you in class today. My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center. And this class is devoted all to the Supreme Court and the big cases of 2023. So we're going to dive into how the court works, who's in the court, how are they nominated, and also those cases that get to the top of the court and the three that we'll be looking at this year. And thank goodness I'm not alone in doing this great work. We get to have Tom Donnelly walk us through all of this amazing content. So everybody welcome Tom. He's our Chief Content Officer. I was going to say Chief Scholar. You're that too. You're Chief Scholar, Chief Contest Officer at the National Constitution Center. Tom, how much do you love this class?
Really fun. We get to talk about some nuts and bolts of how the Supreme Court works, and also about some of the cases that'll be decided over the next month.
So always my favorite kind of balance. We talk about how stuff works, we talk about the history of the courts, and we get to talk about the modern implications of the courts. So let's dive in. We're going to start with some simple questions. This is an introductory level. So hello to the Cunningham class. Hello to everybody out there. If you want to answer in the chat, we would love to have this fun pop quiz with you. So question number one, you can put the number one and then your answer. Number two, and then your answer. Number three, answer. Four, answer. You got the gist. So question number one is, how many justices are on the Supreme Court? So feel free to put that in the chat. Share it with everyone. I'll give you guys a minute to do that as I start to ask the second question. So how many justices are on the Supreme Court? Question one. Question two, who nominates and confirms the justices? Trick question there. Who nominates and confirms the justices? That's a two-parter, people, a two-parter. So you can answer that one in the chat. And next question, that's a hard one, so I'll give you a second. There we go. What are the three levels of the federal court system? That's a super hard question. Yeah. Tom, these questions are zingers, but we'll get to all of them in class today. I feel like 2 years ago, I don't know if I could have answered that quickly. And then finally, what are the qualifications for justices? That one, I don't need to overthink it. Think about when they were writing the Constitution and what are the qualifications for justices. So I'll give everybody a second to kind of put that in there. And Tom, we can begin with having you answer number one. How many justices are on the Supreme Court?
There are 9 justices on the Supreme Court. Article 3 of the Constitution places the power in Congress to decide how many justices there will be there. We've had as many as 10. But we've been at the number 9, for since the late 1860s.
As many as 10, number 9. Has there ever been conversation in recent years about changing that number? Is 9 a sweet spot number we're going to stick with?
Well, I mean, there are famous examples like FDR's attempt to increase the size of the court during the New Deal, and you will see arguments for expanding or reducing the size of the Supreme Court when you have broader arguments about the Supreme Court's role in our constitutional system.
Fantastic. Okay, second question. Who nominates and confirms the justices? So we have the Cunningham class says President and Congress. Janessa says that President nominates. Chris says confirmed by the Senate. And then Warren jumped in there with President and Senate. What is the answer to who nominates and who confirms the justices?
Absolutely. The key text is in Article 2 of the Constitution. It says the president shall nominate. So the president does the nominating, and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. So the Supreme Court decides whether or not to confirm the president's nominees.
Fantastic. Okay, next question is the hard one. What are the 3 levels of the federal system? And I am going to totally give a shout out to Chris Marsh in here. Nice job. He has, they have district, appellate, and SCOTUS. So Tom, walk us through kind of these levels. Nice visual graphic to support you.
Absolutely. So, I mean, yeah, there are 3 levels of courts. The lowest level of court is the district courts. So there are 94 district courts distributed geographically throughout the United States. The next level is the circuit courts of appeals. There are 12 geographic circuits, again, throughout the United States. And there's one court known as the Federal Circuit, which is in Washington, D.C. And here's things like trademark and patent cases. And finally, the highest level of court is the Supreme Court.
Fantastic. And last but not least, when I think of these justices, and we're going to talk about each one of them in a minute, I see some of the most accomplished people in our country that are up there on that court, every single one of them. What qualifications do they have to become a justice? And what qualifications do they typically have to become a modern justice?
Sure. So under Article 3 of the Constitution, there are no formal qualifications for justice, which is really kind of interesting. In the end, that's left up to norms that are set by the president and Congress over time. And so these norms have changed. If you were to look 100 years ago, or really like 150 years ago, one key norm was geography. And so we wanted justices that were from different parts of the country. We don't see that as much as anymore. So there's some geographic diversity, but that's not as important a norm. But a norm that's really important today that was less so in the past are things like former experience as a judge. It's not true of every justice. Elena Kagan was Solicitor General, but not a judge prior to becoming a justice. But we see judicial experience as an important factor. Obviously, qualifications as a lawyer is an important factor. And so, again, it's all to say that Article 3 sets no formal qualifications for who's going to be a Supreme Court justice. These norms, they're set by norms, set by the president, what they're looking for and what the Senate's willing to confirm. And those norms do change over time.
Fantastic. Was this always like, I mean, I think of it such an amazing job. It's such a huge accomplishment to get on the Supreme Court. And there is something about the court that feels like even during times of tension, the court tends to feel like the branch that feels most respected. So the easiest way to say it, like they feel really respected. Was it always the case for the role of justices? Or was it like the job you're really like, it was the top of your field?
No, its prestige and reputation has ebbed and flowed. I mean, at the founding, there were people like John Jay who thought it was a better job to be governor of New York than a Supreme Court justice because he didn't think anything was happening there. And so, over time, the court has had relatively greater or less respect, and the job of Supreme Court justice has been either more or less appealing. The period I study is the late 1800s, and the court then was really, really busy. The court heard over 1,000 cases a year, and the justices themselves were really, really overworked. So in many ways, that job was harder than the one we have today, where the court is only hearing around 60 or 70 cases a term. So the job itself changes, the prestige of the court changes, and as a result, how appealing it is for potential nominees changes as well.
Fantastic. And Chris just did something in the chat, which I absolutely love. And you guys can feel free to share all if you want. He just put a name in, like Earl Warren. So I'm going to just share with all the students. Feel free to put in the chat some names of justices that you know. It could be because they were fantastic or because they weren't so great, because we can list those names as well. But as we go through class, we'll kind of pull up some of these names. We'll definitely be talking about Earl Warren today. But let's begin with our current Supreme Court. This is considered the Roberts Court. Tom, just for making sure we all have it straight, why is it called the Roberts Court? And then can you walk us through all of the people here, maybe as you talked about like geographic diversity, where are they from? And what's kind of their background before they got on the court? That would be really helpful to put in those theory things that we just talked about into the court we have right now.
Yeah, sure. So, I mean, it is known as the Roberts Court because we typically name the courts after the Chief Justice. And so the Chief Justice of the United States is Chief Justice John Roberts, who you see in the middle there, labeled number 1. The justices in this picture, which they take each year, they're seated by seniority. So it's not an aesthetic choice as to who's sitting where. This is really
not by height.
Set in place. And if you had been at the class last year, you would see that the picture last year was different than this year, because we added Justice Jackson, which then wound up shifting literally everyone in the picture, or just about everyone in the picture, around. And so the first person there, again, it's John Roberts. He was appointed by President George W. Bush in 2005. So even though he has not served on the court the longest period of time, the Chief Justice is always the most senior justice. And so he's number 1 there. He's originally, I might not be able to do everyone's background in terms of geography. He's from Indiana. Right before being a Chief Justice, he was on the DC Circuit. So he served on that appeals court. And he was also a really, really well-respected appellate advocate. So he was one of the best known and most respected people who argued before the Supreme Court. So number 2 there is Justice Clarence Thomas, who was nominated by President George Herbert Walker Bush in 1991. He was also on the DC Circuit prior to serving on the Supreme Court. And he had also served in the executive branch, for instance, in the EEOC, which deals with civil rights claims. Justice Thomas is originally from the Deep South, from Georgia. If you shift over to number 3 there, it's Justice Samuel Alito. He was appointed by George W. Bush in 2006. And so he's another one with judicial experience. He was on the U.S. Court of Appeals for the Third Circuit, which is our home circuit at the Constitution Center, covers New Jersey, Pennsylvania, and Delaware. And he himself was originally from New Jersey, I believe. If you then go to number 4 on the end there, that's Justice Sonia Sotomayor, who was nominated by President Obama in 2009. And so she's another one. She was previously a judge, both in the U.S. Court of Appeals for the Second Circuit. So she was an appellate judge. She was also a district court judge as well. So she has experience at every level of the federal judiciary. She was also a prosecutor, a government prosecutor early in her career. So she has a really varied and interesting career. If we go to the other side to number 5, we have Justice Elena Kagan, who was also nominated by President Obama in 2010. Immediately prior to being a justice, she was the Solicitor General of the United States. That's really the government's lawyer before the Supreme Court. So she'd argue cases before the Supreme Court. Famously, she was also the Dean of Harvard Law School. So she had a very well-respected academic prior to being on the Supreme Court. If you go up to the back, number 6 is Justice Neil Gorsuch, who was nominated by President Trump in 2017. He also comes in with judicial experience. He was in the U.S. Court of Appeals for the 11th Circuit, and so he is he's actually from Colorado, and so he's from out west. Number 7 then is Justice Brett Kavanaugh, who was nominated by President Trump in 2018, and so he's another one. He came in with experience as a judge on the D.C. Circuit. And then prior to that, he had extensive experience in the executive branch working for presidents. And so then if we go to number 8, we have Judge Amy Coney Barrett, who was nominated by President Trump in 2020. She was a member of the U.S. Court of Appeals for the 7th Circuit, which covers sort of Illinois and the center of the country, also Indiana. Prior to being a judge, she was a well-respected academic at Notre Dame Law School. She's also she's an author for one of the National Constitution Center's interactive Constitution essays as well. So she's part of the National Constitution Center family in that sense. And then finally, we have number 9 there, Justice Ketanji Brown Jackson, who was nominated by President Biden in 2022. She's another one like Justice Sotomayor, who has experience at each level of the federal judiciary. Just prior to being a Supreme Court justice, she was a judge on the DC Circuit Court of Appeals, and prior to that, she was also a judge on the district of the district court. And so you could see one key credential, Curry, that really comes through as we're looking at these justices is there's a lot of DC Circuit judges. So a lot of people look at the DC Circuit as the second most important court in the country because it hears a lot of cases that are challenges to regulations passed by the government. And so we see a lot of judges here on the justices on the United States Supreme Court were DC Circuit judges prior to their ascension.
And Barry shared that that was a qualification, which I get it, Barry, that totally makes sense. So nice job on that comment earlier. And Susan asked if we would add into the roundup this week who they replaced, who each one of them, like who left and when they came in. I shared, I can definitely do Jackson, that was prior, but we can share that out after class and make sure you have that connecting of who they are, where they're from, and who they replaced, because it is helpful to give that kind of context and understanding. Now, Tom, we talked about, John Jay saying that the court didn't have a lot of power, but when we think about what the court's role is and its job is in the system, in balancing of powers and in the system of national government, it really kind of helps to explain the power of the courts and the importance of the courts as well. So maybe we start with how does it work as a system of checks and balances within the structure of national government? And then let's go through some clear definitions: judicial review, judicial supremacy, all those pieces.
Yeah, so fundamentally, again, Article 3 of the Constitution sets out the judicial branch. It's headed by the Supreme Court. And the Supreme Court itself, and the judicial branch as a whole, is responsible for interpreting the laws. This has a couple of components to it. One is that in ordinary cases that are not constitutional cases, it's the Supreme Court that will sometimes interpret laws passed by Congress, regulations passed by the executive branch, executive orders issued by the president. And so part of what the Supreme Court's doing is simply, looking at legal text and trying to give it meaning in just ordinary cases. The other key thing it has, and maybe we could go into the definition here, Curry, is the power of judicial review. And so the power of judicial review is the power to review the constitutionality of acts of national and state governments. These could be laws passed by legislatures, actions taken by the executive. It could govern things like your interactions with public school principals or with police officers. All of these are actors within the government, and so their actions can be reviewed by the courts in this function of judicial review. And this is where you see the interaction, some of the checks and balances between the president and the other branches of government. Sometimes the Supreme Court will take a law passed by Congress and say it's constitutional, so Congress has the power. Sometimes it'll take that law and it'll say, no, this exceeds Congress's authority and it is unconstitutional. And it could do the same things with actions taken by the president, whether it's regulations passed by executive branch agencies, executive orders issued by the president, et cetera. And so that's a core power that the judicial branch has.
Fantastic. And really, you think about this as the branch of government that is really supposed to be keeping an eye on the prize and saying, is everybody doing their role? Is everybody staying in their lane? And how are we mitigating between the branches? But we've had definitely other branches say that that's their job too, to be the check on the Constitution. I always think of Jackson and the presidency. So is it would you say it's solely in the Supreme Court, or is it really the role of each branch, and the Supreme Court has, when it's in conflict with the people, when it's in conflict between the branches, like where's that balance?
Yeah, so every branch of government has an oath to uphold the Constitution. Public officials take that oath. I took that oath when I was a judicial law clerk. And so everyone takes that responsibility really seriously. We've seen throughout American history great debates between the Supreme Court on the one hand weighing in on a constitutional issue and those outside of the court saying the Supreme Court got it wrong. And so a key example in history is Abraham Lincoln, none other than Abraham Lincoln. What was one of his key arguments before he was president of the United States? It's that Chief Justice Taney in the Supreme Court got it wrong in the Dred Scott decision. There, the Supreme Court said that African Americans couldn't be United States citizens and had, quote, no rights which the white man was bound to respect. And Abraham Lincoln said, no, that is absolutely wrong. And what he said was, on the one hand, I'm not going to defy the Supreme Court. I'm not going to call for violence. And I'm not going to say we shouldn't stand by the particular judgment in that particular case. But I, as a political actor, am going to be out here explaining why I think it gets the Constitution wrong. And furthermore, if I become president, I'm going to make sure that I can appoint justices that have a different vision. And also, I'm going to push for constitutional amendments that can correct the Supreme Court. And we wound up getting them after the Civil War in the case of the 13th Amendment, abolishing slavery, and the 14th Amendment, overruling Dred Scott and saying, yes, African Americans can be United States citizens. And of course, they have many rights. They have just as many rights as everyone else that everyone is bound to respect.
Fantastic. Thank you. That was perfect. Now let's dive into a few more definitions. Judicial supremacy. So explain kind of what this means and how it came about.
Absolutely. So judicial supremacy, this is the key term used in that debate over how much authority the Supreme Court has. Judicial supremacy is the argument that the Supreme Court is the final voice on questions of whether actions by the national government or state governments are constitutional. It's a contested concept. So some people argue in favor of judicial supremacy. Others, like Abraham Lincoln, say, no, that's not our system. And in fact, we all have a duty to interpret the Constitution and get it right. And we have a duty to speak back to the Supreme Court when we think that they get it wrong. And it's to be distinguished again from judicial review. Judicial supremacy is really giving the Supreme Court a final say on all questions and saying that basically, even if we disagree, we should no longer disagree and we should yield to the Supreme Court. Judicial review is just a formal power that's in an individual case where the Supreme Court's going to decide whether an act of the government's constitutional or unconstitutional. If you're looking for some of the big arguments for why judicial review is present in the Constitution and also why it's important. Two key sources would be a key Federalist paper essay written by Alexander Hamilton, Federalist number 78, where he explains on the one hand that he thinks the courts are the weakest branch of government, but on the other hand, he explains why big things like judicial review and judicial independence are such an important part of our constitutional system. The key Supreme Court decision on judicial review, the early one, is Marbury versus Madison, which is written by Chief Justice John Marshall in 1803, and it affirms the power of judicial review within the federal courts. This is all to say, the Constitution itself doesn't have a judicial review clause of the Constitution, but these two sources explain where we can derive that right from the text of the Constitution and its structure, in part because the judicial branch, Article 3, grants the judicial branch, the federal judiciary, the judicial power of the United States, that part of that power at the time when the Constitution is framed and ratified would have included something like the power of judicial review, and that finally, Article 6, the supremacy clause of the Constitution, makes the Constitution superior to all other sources of law. So as the Supreme Court is interpreting the laws, it's going to have to give priority to the Constitution, the voice of we the people, over other acts of the government, which are acts by we the government.
Fantastic. That's really helpful. And we'll send out those links to Fed 78 and Marbury versus Madison. And we'll also send out the video of the class that we did earlier this year that goes over those cases, the cases that we're going to talk about today in more detail. So you can grab the landmark cases, grab the Supreme Court class and blend them together. And yes, we are recording this one. Okay, so next is judicial independence. What is judicial independence, and what is the importance of having the Supreme Court, the courts as a separate branch on their own?
Sure. So judicial independence, it's the idea that the federal courts have to be independent from the control of the other branches. This is in contrast to what the American colonists experienced with royal judges, where royal judges, they depended on the king and parliament for their jobs, and they could be fired by those political actors if they made decisions that those political actors didn't like. And we said with our Constitution, we don't want that. And so the Constitution in Article 3 carves out judicial independence as a key principle. And this is done by giving judges and justices life tenure and guaranteeing their salaries. So judges can only be removed through the impeachment and removal process. We've only seen one justice ever impeached in American history. That was Samuel Chase. He was a Federalist justice who was impeached by the Jeffersonians when the Jeffersonians took power after the Revolution of 1800.
Fantastic. Now, a question for you. This sounds perfect. Like this sounds like the way it should be, but there are people that don't think it's the best idea. What are some of the cons of life tenure? Would be one of them.
Well, I mean, so the famous theorist here is someone named Alexander Bickel, who called judicial review and judicial independence, they were sort of deviant institutions in the American system, is what he said. And he said that for a government that is premised on we the people and by democratic accountability over time, we're creating a branch of government that's really powerful and that isn't accountable to the people. And so therefore, in the end, courts aren't infallible. They're going to get things wrong. And there's a danger for having courts decide big constitutional questions without easy forms of accountability. So on the one, again, it's a balance. On the one hand, there's a danger to just having a judiciary where it's like super accountable to something like a king or a parliament. But critics of judicial independence and judicial review say there's also a danger to a lack of electoral accountability. In the end, we've decided to create a system that's really high on the independence scale and high on the possibility of the courts deciding big questions under judicial review. But different constitutional systems strike different balances when it comes to those questions.
Fantastic. Okay, we got 7 minutes left, and I definitely want to do a quick walk by of the big cases this year. But could you help us kind of understand how does a case get to the court in the first place? So what does a typical Supreme Court term look like? Real quickly, how does a case get to them? Because it really does start with we the people. It doesn't start with we the courts. It starts with people and their actions. And then can we look at the 3 big cases of this year that our students should be really paying attention to in the news, because they're going to see them probably in the next 3 to 4 weeks, right?
Yeah, absolutely. Yeah. So the flow of the term is it really goes from the first Monday in October until usually the end of June. There's no set endpoint to when the term has to end. The Supreme Court gets to make up its own rules. But in the end, the court almost always finishes by the end of June. And so during the course of that time, the justices are getting petitions asking them to hear new cases. For the cases they decide to hear, they're receiving briefs from the parties, which explain the legal arguments on both sides. They're holding oral argument in the cases they decide to hear. So hearing from the advocates themselves in a conversation between the justices and the advocates. They're meeting together in their private conference to decide whether, how they're going to vote on a given case. And then in the end, they're spending a lot of their time writing opinions. And so these opinions are majority opinions, which is where an opinion really gets the support of all of a majority of the justices on the court. There are dissenting opinions where justices explain why they disagree with the majority. And then there's concurring opinions where justices may agree with the majority, but may have more things that they want to say. If we're really looking at how does a case get to the Supreme Court, most of them, are going through those systems of courts that we talked about at the beginning of class today. As Curry said, often these things begin with we the people or me the individual. The government, if we're talking about constitutional cases, so the government did something that violated the Constitution. Through a law, through a regulation, through something a school principal did, through something that police officers did. And so that's the initial constitutional argument. And then it works its way through from the district courts, where they'll have a case before a single judge. The loser may then appeal to the courts of appeals, where often they will appear before panels of 3 judges. And then finally, if you lose in the Court of Appeals and you want to get to the Supreme Court, you'll do what you call petition for a writ of certiorari. It's just a fancy way of saying you're asking the court to take your case. There's roughly 7,000 to 10,000 of these petitions per year. The Supreme Court decides to take 60 or 70 cases. So it's a reminder, the court doesn't decide the vast majority of the cases that we have throughout the country. The court's going to take cases that either they see as of great national importance and or where we've seen a conflict in how the lower courts have decided the issue. So the Supreme Court won't step in to correct every mistake, but they may step in to try to set a uniform rule that's going to apply everywhere, because they don't want different legal rules applying in one part of the country versus another part of the country.
Well done, Tom Donnelly. That was brilliant, beautiful, and really quick. So I appreciate it. Just one quick question. Out of those 7,000 to 10,000 that don't get heard, can they resubmit? Like, what is no?
That's the end of the line. That's the end of the line. So
wow.
That's the end of the case. And again, the key rule here for how the Supreme Court decides whether or not to take a case, it's the rule of 4. So 4 of the 9 justices have to say that they want to take a case, and then it ends up on the docket. That's, again, a product of a law passed by Congress in 1925 that was pushed by Chief Justice Taft after he was president, that gives the Supreme Court, the modern Supreme Court, the control over its docket, the control to take some cases and not take others. Prior to then, the Supreme Court had to decide a ton of cases it frankly probably didn't want to.
Got it. Perfect. Okay. Real quick, the last 3 minutes, can you walk us through the big 3 cases and what to pay attention to in the upcoming weeks on these cases coming out of the courts? So let's start with 303 Creative.
So 303 Creative, it's a big First Amendment case. And the case involves Lori Smith, who's a website designer and a devout Christian who wants to expand her business to include wedding websites, but she doesn't want to create wedding websites for same-sex couples. So Smith here is challenging a Colorado law that bans most businesses from discriminating against LGBTQ customers. She argues that requiring her to design websites for same-sex couples basically compels her speech in violation of the First Amendment. Her argument is that the Supreme Court generally doesn't approve efforts to compel speech that runs against a speaker's beliefs, and also that she's not trying to create new law. She's just asking the Supreme Court to apply precedent that it has already established, most importantly in a 1995 decision called Hurley, which held that Massachusetts couldn't require the organizers of the Boston St. Patrick's Day parade to allow a group of LGBTQ folks to join that parade. That's her side. The other side, Colorado argues, on the other hand, that a ruling in favor of Smith would be the first time the Supreme Court had ruled that a business could refuse to serve a customer based on race, sex, religion, or sexual orientation. What it says is that basically this case is just requiring businesses that serve the public to serve everyone. And they also warn against the possible consequences if Smith wins, saying that it may create a really sweeping rule that doesn't just permit sincerely held religious beliefs like Smith's to win, but also really nasty and bigoted beliefs to win as well. And so it's a big First Amendment case, 303 Creative versus Elenis.
Great. That's going to be a really interesting one to see what comes out. And as you said it earlier, we always encourage our students to read the opinion, the dissent, and the concurrence, all parts of those cases when they come out, because they are all really fascinating. Okay, so this one's a little bit harder, but really, really interesting. I taught this a month ago to a group we were working with at the Union League. Can you tell us about these two cases that we're lumping under the loan forgiveness cases?
Yes. So we'll try to keep it as simple as possible. These are two cases. There's Biden versus Nebraska and Department of Education versus Brown. These are states and individual borrowers who are challenging President Biden's student loan forgiveness program. And so this is the program that was announced last August that will forgive up to $20,000 in student loans for qualifying borrowers. The Biden administration here relied on something called the HEROES Act, which was passed after 9/11, that gives the Secretary of Education the power to respond to national emergencies by basically altering the conditions of student loan agreements that are held by the government. And so there are really two big constitutional questions here. One is a really fundamental question of whether either the states or the borrowers have what's called standing to sue. And so this is whether they can bring their cases to begin with. The big idea here is that the federal courts, they don't decide just abstract questions of law or under the Constitution, but that the challengers themselves have to actually be harmed. And so I'm not going to say much more about it than that, but that's one key question, is whether or not the challengers have standing to sue. And then the big question on the merits is, if they do have standing to sue, whether the plan exceeds the Secretary of Education's authority under this law passed by Congress. The challengers here argue that the Biden administration has exceeded its authority, that it doesn't have the power under the HEROES Act to create a student loan forgiveness program like this. Their main argument is textual. And so they look at the act and they say the act gives the Secretary of Education the power to waive or modify any statutory or regulatory provision governing the student loan programs. And they say, frankly, that the program isn't a waiver or a modification. It's something way bigger than that. And so therefore, the president's acting outside of his authority under the act, or really the Secretary of Education is. The other part, though, is that they say, even if you think it's a close question, that the court should apply what's known as the major questions doctrine, which is a principle of statutory interpretation that says that if Congress wants to give an agency of the executive branch, someone like the Secretary of Education, the authority to make a decision that has, quote, vast and economic political significance, it has to speak clearly. The statute has to be super duper clear. And what they're saying here is that the statute is not clear, and so the administration should lose. The flip side is that the US government says that the act's text actually is really clear. It says waive or modify. Waive is actually a really broad word. And so what we're doing, and furthermore, that the act itself is meant to address national emergencies. We just had COVID, we had COVID pandemic, that's a national emergency. And so that this student loan forgiveness program fits squarely within the text of the statute.
This one's really, really interesting. And I think you did a perfect job. You made it very clear and concise and really laid out the pros and the cons of this. Now, the last grouping of cases are what's under the affirmative action cases. So explain to us what's going on with these cases and what are the two sides in conflict with each other over what pieces.
Sure. So these are two cases dealing with the admissions policies at one at the University of North Carolina, the other at Harvard. The big question in both these cases is the number one that you see there, which is whether the Supreme Court should overrule Grutter versus Bollinger and hold that institutions of higher education can't use race as a factor in admissions. Grutter was decided in 2003. And effectively what the Supreme Court said there is that the University of Michigan Law School can use race as one factor among many when trying to create its student body. And so it allows universities in the context of university admissions or law school admissions to use race as one factor among many. It can't be the predominant factor, it can't be the decisive factor, but it can be one factor that's used in this context. Also in the Grutter decision, which was written by then Justice Sandra Day O'Connor, she also said that, in 25 years, I don't think that we're going to need affirmative action in this context, or it's sort of expressing that aspiration. And so we're 19 years after Grutter, and the Supreme Court is now basically returning to the same question and asking the question of whether or not universities can use race as a factor in admissions. This case, the North Carolina case is under the 14th Amendment's Equal Protection Clause. The Harvard case also brings in a key civil rights law, the Civil Rights Act of 1964. But again, both questions are fundamentally about whether or not race can be taken into account in university admissions. The challengers in the case it's an organization known as Students for Fair Admissions. They brought the challenge in both of these cases, and they effectively argue racial classifications in university admissions are wrong. They violate the 14th Amendment's commitment to a colorblind constitution. They run against key cases like Brown versus Board of Education, which said that the idea of racial classification shouldn't be allowed in the context of education. And finally, because of that, they call on overruling Grutter and the case that came before it, a case known as Bakke, and to say again that higher education can't use race as a factor in admissions. On the flip side, we have the University of North Carolina, Harvard, and the US government arguing basically that the Supreme Court should reaffirm, uphold Grutter, Bakke, and the idea that there's value to diversity in university admissions. On this view, again, universities should be allowed to use race as one factor among many in university admissions. They argue that affirmative action itself is consistent with the text and history of the 14th Amendment and its original meaning, and also that the consequences of eliminating race in university admissions would be massive. And so it's a combination sort of text, history, doctrine, and then finally consequences.
Awesome. I loved how you wrapped that up with looking at the methods that the arguments are based in as well, the constitutional methods for argumentation. So I love that. That's perfect. Again, we can send that class out to you all as well. And all of the cases that Tom just cited as reference cases, we will do in the weekly roundup. And Tom, we should see some of these cases starting to hit at the end of June, middle of June, end of June. So when should we be paying attention to the news for some of these cases to come out? Their decisions, their opinions, dissents, maybe some concurrences.
I mean, technically, it could be literally any day. My guess for these three would be towards the very end of June, probably the last week of the Supreme Court's term.
Fantastic. Thank you so
Maybe
much.
The same day. Sometimes it cashes out that way.
Big ones, dropping the big bombs all on the same day. Students, thank you so much. There's a couple questions in the chat and the Q&A that I'm going to ask after this, but if you need to jump, we understand. Tom, fantastic job. I'm going to stop recording.
Thank you, everyone.
Sure. Really great question in the Q&A here. So what do you think accounts for the difference in productivity in the current court and the period that you studied in the 1860s?
Well, in part,
or 1800s.
Yeah, so like especially why the workload is so different. It's in part because of the sort of the framework Congress put in place by the laws that it passed. And so prior to the Judges Act of 1925, the Supreme Court simply had to decide a bunch of cases. And it didn't have control over saying, yes, I want to take this case, and no, I don't. And so you had all sorts of cases that, frankly, the court would never take today, that a lot of them were not involving even questions of national law or the Constitution, but it involved people from different states. And so one of the ways in which federal courts can hear a case is if a person from one state sues a person from another state, even if it has to do with state law. So they heard like a bunch of cases that had nothing to do with federal law and had everything to do with disputes between the cases. There were also just like really weird cases, like there were a bunch of land claims that came out of the Mexican-American War out west that the Supreme Court heard like hundreds of these cases every year as we got into the late 1800s. And so there are just a lot of cases, but this is why President Taft pushed so hard once he became Chief Justice to try to make the Supreme Court's job more focused on what he would, I'm sure, say would be the most important cases, making sure that they don't have to, that they could really focus on what are the most important constitutional and legal issues throughout the country and really focus their attention on those cases. And so with the Judges Bill, again, we get the Supreme Court able to decide, I'm going to take this case or I'm not going to take this case. Similarly, Taft is, and just to give a shout out to Chief Justice Taft, Taft is also the reason why we have the Supreme Court building that we have today. For prior to the Supreme Court building we have right now, which is beautiful building right across from the Capitol, the Supreme Court actually held its argument in the basement of the Capitol in the old U.S. Senate chamber. And so Taft also thought it was important. We're an important branch of government. We do important work. We are worthy of a grand temple to the law. And so that's why we have the Supreme Court building we have today. Taft tragically passed away before that building was completed, but that was also an important part of his legacy as Chief Justice.
Oh, that's fantastic, Tom. Thank you for that. And also, we were just at the Supreme Court, what was that, like 2 weeks ago, Tom, for our meeting? The tour of the courtroom. If you ever go on that tour, ask about I don't know, it's not mosaic, it's a relief that is surrounding the courtroom at the top. Their team there, their staff there did the most amazing walkthrough of all the reliefs on the top. It was so much fun. It was probably 20 minutes and we were all like gaped mouth and be like, who's that? Who's that? And it was a bunch of adults and not children. You would have never guessed. It was a brilliant tour of the Supreme Court. So if you ever get in there, they always bring people into the courtroom when they're not in court, and you can ask lots of questions, and the staff was fantastic. So thank you for that fun fact. And it built on time and under budget. Thanks, Warren, for adding to that too.
Well, Taft was a remarkable administrator throughout his career, including before he was president. He knew how to get things done.
Awesome. And I love that he had the job, the experience of the job, and then was able to, in his next role, help make it more effective in its roles. That was great class. Thank you so much, time. Thank you, students. Great time in class. And we have a 2 o'clock program today and a 1 o'clock program all Eastern time on Friday. So see you next